The broadcast is now starting. All attendees are in listen-only mode.
Hi, good afternoon, everybody. We're going to get started. Thanks for joining us today for today's webinar, the Buy American Act and the Trade Agreements Act, Understanding Federal Domestic Preference Requirements. My name is John Williams, as you see our smiling faces popping up here, and I'm very pleased to be joined by my colleague Jackie Unger. Both Jackie and I work in the government contracts group here at PilieroMazza, one of the several practice groups that we have. Many of our lawyers work with labor and employment issues. We have folks that work in our corporate group and also in litigation. And like many of the things that we handle here at PilieroMazza, today's topic does have some crossover between some of our different practice groups. Domestic preference laws, in particular BAA and TAA, Buy American Act and the Trade Agreements Act, are primarily government contracting issues. So when Jackie and I encounter them, what we're seeing from clients are questions about, hey, I'm going to bid on this contract, and the solicitation has BAA and TAA provisions in it. Does that make sense? What do I have to do? Which one am I supposed to comply with? Or a client is putting together a subcontract agreement and is wondering, why is this BAA requirement being flowed down to me as a subcontractor? Or maybe it's come up in a protest issue or something along those lines. So there's a variety of ways that it comes up in the government contracts group, but it can also turn into a corporate issue because you're maybe putting together a corporate compliance program or updating internal policies and procedures for how are you making these determinations of compliance and the certificates and checking on suppliers and training your people. These are all important components of a compliance program. And unfortunately, it can also turn into a litigation issue. And we've seen that happen, I think primarily False Claims Act cases, but there can also be disputes between primes and subs over compliance issues, particularly, when the prime contractor ends up being liable and maybe it was the subcontractor's fault for a liability issue. So, because of the different ways that this issue intersects in our different practice groups, we've been seeing a lot of it recently, and I think with the new administration, there's been an increased focus. Everybody's very well aware of the red hat, Make America Great Again, and an offshoot of that has been executive orders, and I would just say an increased focus on domestic preference. And so with that climate, we thought this is a great topic and an opportunity to drill down on BAA and TAA compliance, and that's what we're going to do here today. So we're really glad that you joined us for that. We're going to give an overview of these laws and why you should care about them. We're going to talk about, we're really focusing on BAA and TAA and when they apply and what they require. We're going to talk a little bit about small business and federal supply schedule contracts. How does the BAA and TAA intersect with those issues? And we're going to give you some practical tips for compliance. And as much as possible within the time we have left, we're going to answer questions at the end. We'll try to save some time at the end for questions, but don't hesitate to fire away with questions in the chat box as we're moving along. If we can answer midstream, we will. And anything that we don't get to during today's presentation, we'll follow up afterwards by email. So please don't be bashful about asking questions, including if you're wondering an update on the Rhode Island-Oklahoma game. Yes, I am following that. We do appreciate you guys taking the time to participate in this during the first day of the tournament, and we totally understand if you're multitasking as we go through. So without further ado, I'm going to turn it over to Jackie Unger.
Yeah, so first we wanted to highlight the federal domestic preference laws that are at play. And basically, what are they? Well, the federal government has a long-standing preference for the purchase of domestic products over foreign products. So there's quite a bit of legislation out there to implement that preference. The biggie is the Buy American Act of 1933, which it's written as a restriction, but essentially it provides preferential treatment for the purchase of domestic products and construction materials under federal government prime contracts. Then we have the Trade Agreements Act of 1979, which implements trade agreements guaranteeing non-discrimination of eligible foreign products and essentially treating those foreign products as domestic products while prohibiting the purchase of ineligible products and services. So those are the two that we're going to do a deeper dive in today. But we also just wanted to mention a couple others. There's the Berry Amendment, which requires that certain Department of Defense purchases, for example, food, clothing, certain textiles and tools, and acquisitions of aircraft, missiles, or space systems, ships, tanks, or automotive items, weapon systems, and ammunition be entirely grown or produced in the U.S. For those later ones that they relate to the specialty metals, the specialty metals on those aircraft, missile systems, et cetera, have to be grown or produced in the U.S. And the Berry Amendment is more restrictive than BAA and TAA. They have to be entirely made in the U.S. And then Buy America, which is often confused with the Buy American Act, is often referred to as Buy America Act, but it's really not a single statute or a program. It refers to a set of domestic content restrictions that are attached to federal funds provided to states and local governments, generally covering transportation projects using DOT funding. So for DOT administrative agencies such as the Federal Highway Administration, Federal Transit Administration, Amtrak, Federal Railroad Administration for high-speed rail, and FAA. So, and in addition to these, there are also other domestic preference statutes and regulations that exist within specific agencies with their own unique rules. So, you need to pay attention to which specific ones apply, but the big ones are BAA and TAA, and that's what we're going to focus on here. So why should you care about these laws? As John was mentioning, we've got the renewed focus by President Trump. His platform was on Buy American, America First. So in that regard, he's issued some executive orders, the Buy American and Hire American Executive Order and addressing trade agreement violations and abuses in last April, which basically require agencies to assess monitoring, compliance, implementation, and enforcement of Buy American laws and assess the use of their waivers and exceptions to those laws, and also require the review of U.S. trade agreements. And it requires the Secretary of Commerce and U.S. Trade Representative to issue a report regarding those assessments and making recommendations to strengthen the Buy American laws and to identify actions to remedy violations or abuses that are identified with trade agreements. So the Department of Commerce and OMB have issued a memo directing agencies to look at compliance with their BAA requirements and how they can how they're using their waivers. So that's pretty much the first step under the executive order, but they haven't come out with their report with recommendations on how to strengthen the Buy American laws.
Yeah, and I'll just jump in there. As we move forward and talking more about the BAA, we'll get into exemptions and the various ways that you can get around the BAA for a particular procurement, because generally speaking, it's intended to be a preference for American as opposed to a prohibition. But I think this memo that Jackie's talking about and this direction to agencies to really start providing more details on the ways that they're getting around the BAA is obviously intended to put more of a spotlight on how often are agencies utilizing the exemptions and essentially going around the BAA.
And so there's also been recent legislation to try and strengthen Buy American laws. Just a few examples: the Buy American Improvement Act of 2017 was introduced in February of 2017. It was designed to apply Buy America laws and BAA rules more broadly and to reduce the use of BAA waivers and exceptions, requiring further justifications for those waivers, and also seeks to increase the domestic content requirements under BAA. So we'll get into what the thresholds are for how much domestic content you need for an end item to qualify as being domestic. And so some of this legislation is trying to increase the threshold that you need to be for your item end product to be considered a domestic end product. The 21st Century Buy American Act, which was introduced in December of 2017, again, it is attempting to increase the threshold for domestic content requirements. And it's also seeking to require reports from agencies and the Department of Commerce on compliance with BAA and, again, the use of waivers and exceptions. And then more recently, in January of 2018, BuyAmerican.gov Act of 2018 was introduced in the Senate. This is bipartisan. Again, it requires the reports by agencies and the Secretary of Commerce, again, on compliance with BAA and the use of the waivers and exceptions every 2 years. And it also would establish a website for increased transparency on the use of waivers. And it would not allow agencies to approve the use of a waiver or exception of BAA requirements unless information is provided on the website and there's an opportunity for public comment beforehand. So it's meant to streamline the acquisition process where BAA is involved, but with those extra requirements, it could actually make it more complicated. So you can see that there's a lot of concern that that exemptions and waivers to Buy American laws are being overused, and Congress is interested in trying to limit that. And until that memo comes out that the Trump's executive order required with recommendations about how to strengthen Buy America laws, it may not be the case that any of this legislation is passed immediately, but it definitely seems like it's on the horizon at some point. So we need to be aware of what's coming down the line. And then the other reason you should care is that compliance is really critical, because if you don't comply, there could be serious repercussions. You could be involved in audits or investigations related to your compliance, which could be conducted by GAO, agency, OIG, or by DOJ, which could potentially lead to False Claims Act exposure. DOJ could bring a case, or you could have an employee file. It's a whistleblower key TAM action. FCA liability, obviously, is very serious. It could result in treble damages, or even if it ends up with a settlement, there's likely going to be a press release about that. For FCA violations, you would have mandatory disclosure obligations, and there would be potential suspension and debarment resulting from that. As just a couple examples of this being far-reaching, in 2013, CDW Government LLC settled with DOJ for over $5.5 million in a key TAM whistleblower case, which was originally brought by a former employee, which alleged that the company sold TAA non-compliant IT equipment, office supplies, and similar products to government agencies through its GSA schedule contract. In 2016, Novum Structures LLC agreed to enter a guilty plea and pay $3 million to resolve criminal and civil liability arising from its improper use of foreign materials on construction projects involving federal funds, which were subject to Buy America requirements. So there you're looking at Buy America. And then it's also important to remember that potential liability can extend to suppliers. In 2014, Samsung Electronics America settled with DOJ for $2.3 million in a key TAM whistleblower case. that involved allegations that the company submitted false certifications to its resellers that its products were TAA compliant, and those certifications were then passed on to the government, which caused its resellers to submit false claims for products sold on their GSA scheduled contracts in violation of TAA. Also important to note that even if there is no False Claims Act case that's brought, the government may terminate you the contract, and you could be left with responsibility for reprocurement costs. And you also may face increased vulnerability in post-award protests that your offer doesn't comply with BAA or TAA. And while case law generally holds that an agency may rely on an offeror's certification of compliance, but if there's evidence of noncompliance, the agency generally has to investigate further. So competitors, if they happen to have some evidence that you're not complying, they might want to bring a protest and share that with an agency, and then say that the agency didn't follow up on that as they should have.
Yeah, and we're definitely seeing more in the way of this being raised by competitors, in the protest context or in other means that competitors might lodge complaints regarding compliance. There are particular ways that especially BAA comes up in the context of small business set-asides that we'll talk about, and we've had, I think, anecdotally anyway, based on our clients, an uptick in the number of cases where clients are being investigated, as Jackie mentioned, by DOJ or an IG related to certifications and, country of origin issues, et cetera. So it's not just the boogeyman. I mean, it really is the case that there's an increased focus on this, and so that's why we want to help everybody understand, what are these requirements. That's the objective here today. So let's start with BAA and roll up our sleeves a little bit on BAA. I think we might have a typo here in the slide. It's a 1933 Buy American Act. So and we will be sending the slides to everybody after the presentation's over, so don't worry about that. You'll get an email, and we'll go ahead and make that correction before the slides go out, but you'll all get a copy of this, and you'll feel free to forward the slides on and inside your organization or to whomever might be interested. So big picture, I mean, the Buy American Act is helpfully titled. It's pretty easy to tell what we're getting at here just based on what it's called. It's it was designed to encourage purchases of American-made goods, plain and simple. The regulatory scheme here, where we're calling American-made goods, quote, domestic end products or domestic construction materials, because Buy American Act is going to apply to products or construction materials. And we're going to drill down on exactly what is a domestic end product and the tests that go into that. But just big picture at this point, and we say it favors the purchase of domestic end products because while it's written as a prohibition on foreign end products, the way that it actually is applied is as a preference for domestic end products. So there are circumstances where the government can acquire a foreign end product, even though the Buy American Act might apply to that procurement. There might be an exception to the Buy American Act that allows the government to acquire a foreign end product, and we'll talk about the exceptions. But just as a starting point, that this is designed to encourage purchase of American-made goods, and it's essentially a preference, not a prohibition, although it could work as a prohibition, and there's some nuances there that we'll talk about. The preference is manifested as a price evaluation adjustment. So, and you see towards the bottom of the slide here how that price evaluation adjustment works. For civilian agencies, it's going to be either 6% or 12%, depending on whether or not the low domestic offer is a large or a small business. So if the lowest priced offer from a firm supplying a domestic end product is a large business, but there is an even cheaper product submitted by that's a foreign end product, that low domestic offer by a large business is going to get a 6% price preference. If that low offer from a domestic product was from a small business, there'd be an even greater, a 12% price preference. So some of you might be familiar with the price evaluation preference for hub zone firms, as a particular type of set-aside program that on unrestricted procurements, there's a price evaluation preference for hub zone firms comparable to that in terms of how this works. And then an even greater adjustment specific to DoD acquisitions. So next slide popping up here, slide 9, a little bit on the applicability of the BAA. You know, what types of contracts and when does this come into play? It applies to all federal prime supply and construction contracts, but not contracts that are purely for services. And then there's a value of the contract you need to be mindful of. It needs to be a contract that is valued above the micro purchase threshold. So, you know, contracts below the micro purchase threshold, it will not apply to. The most recent National Defense Authorization Act increased the micro purchase threshold from 3,500 to 10,000. But that for civilian agencies, excuse me, I think for DoD it went to 5,000. That change has not gone into the FAR yet for civilian agencies. I think they can do that by a class deviation, but I don't believe it's been done yet. So by FAR at this moment, micro purchase 3,500. By statute, it's 10,000. Below that amount, below the micro purchase, no BAA. Above the micro purchase, BAA applies unless the TAA applies. So as we move forward into the TAA, that'll start to make a little more sense, I hope. But you've got this sort of window between the micro purchase threshold and the threshold for TAA. And there are different thresholds for TAA. We'll get into that. But between those $2 thresholds, the BAA is going to apply. And the BAA might also apply even above the TAA threshold for certain types of contracts. Because, for example, the TAA does not apply to small business set-asides. So if we have a dollar threshold for TAA, in many cases it's going to be 180,000, and we have some slides on that. But so if we have this general window that BAA is going to apply from micro purchase, let's call it 10,000, to the TAA threshold, let's call it 180,000. But there might be circumstances where even though the contract is greater than 180,000 and the TAA might ordinarily kick in, because it's a small business set aside, for example, the TAA doesn't apply, so we'd go back to the BAA. All right, now I'm going to kick it over to Jackie to drill down on the country of origin test. You know, we're really talking about, so if this BAA statute and the implementing regs and the FAR are designed to give a preference for domestic end products, what is a domestic end product?
So first, for non-manufactured products, to qualify, the product must be mined or produced in the U.S. And then for manufactured products, there's a two-part test to determine whether it qualifies as a domestic end product. First part, the end item must be manufactured in the U.S. and the cost of its components, mined, produced, or manufactured in the U.S. must exceed 50% of the cost of all of the components. So you have the manufacturing in the U.S. and then the cost of components test, that at least 50% of the total cost of components come from components that are produced, manufactured in the U.S. Important to recognize that commercially available off-the-shelf items need only be manufactured in the U.S. That second part, the component test, does not apply to COTS, which is defined by the FAR as any item of supply, including construction material that is a commercial item, which is separately defined in the FAR, sold in substantial quantities in the commercial marketplace and offered to the government without modification in the same form in which it is sold in the commercial marketplace. So then, going a little deeper into this, first part of the test is defining manufacture. So how do you know whether it's been manufactured in the U.S.? Well, unfortunately, no clear-cut rules. There's no statutory or regulatory definition of manufacture. But GAO, through its case law, has come up with a standard, and the standard's applied on a case-by-case basis. What you're really looking for is an operation or processing whereby the identity and character of the item is established and fixed as to its current and future use by the government. One important thing to recognize, and we'll talk about later, is it uses a less stringent test than is used under the TAA. So the tests under BAA and TAA for determining domestic product are not the same ones. Assembly of components can be sufficient to constitute manufacturing, but packaging is not. So whether assembly will be sufficient really depends on how complex that assembly is. For example, assembly of multifunction fax, printer, scanner, and copier, which includes assembly of the various subcomponents of the machine, has been found to be sufficient. On the other hand, assembly or operations that do not change the essential nature of the product are insufficient to constitute manufacturing. For example, GAO has held that disassembly and substitution of parts consisting of removal of a circuit board and replacement of memory chips and reassembly in the U.S. of a Japanese-made commercial fax machine did not change the essential function or nature of the fax machine. And similarly, with ammunition-grade cargo containers from China, refurbishing them by replacing floors and panels and fixing dents as needed and then repainting did not change the essential nature because the container, at the end of the day, is still a container, so there's not enough change being done there. So the second part of the test is the component test. The domestic components have to exceed 50% of the total component cost. So it's really important to understand what the component is. It's defined as the item that's directly incorporated into an end product or construction material. So you need to identify whether an item is the end product or a component or a subcomponent, because for calculating component cost, the cost is measured at the component and not a subcomponent level. In one GAO case, a company offering lock sets intended to buy U.S. steel, which was rolled into sheets, and then the sheets of steel would be shipped to Korea for fabrication into the parts. Those parts would return to the U.S. for manufacture into the end item of the lock sets. And GAO held that the fabricated steel parts were the components and not the U.S. steel that was made in the U.S. because the steel was not directly used in the end item. Instead, the steel was fabricated in Korea into the different parts that were used to manufacture the end item. So the steel cost, which was the subcomponent cost, was irrelevant. So for calculating component cost, depends on what you're including, depends on whether you're purchasing the components or whether they've been manufactured. So where they've been purchased, you include the acquisition cost, including transportation costs and applicable duties, and where they've been manufactured, you include all costs associated with manufacture of the components, including transportation and overhead, but not profit. Also want to point out that components where there's an unknown origin, if you can't prove where the origin is, then it's going to be presumed to be a foreign component.
All right, we have a lot of questions that are coming in, so I appreciate that. I don't think we'll be able to answer them all during the webinar, and some of them are fairly specific to your organization. We will make sure we follow up with everybody after the fact, though. But before I transition to some exceptions, I think Jackie just answered one of the questions. I can see here that the component cost would include the labor costs. And somebody else has asked whether the BAA would apply to medical equipment being sold to the VA, and it certainly could and potentially should, depending on the nature of the procurement. So I don't know that we can necessarily give a blanket answer that says that in all cases, medical equipment being sold to the VA would be subject to the BAA, because it might be subject to the TAA, or there might be some exceptions that would apply. So let's use that as a segue to here, the slide you're looking at now, slide 13, exceptions to the BAA. And there's several of them. One of them is for commercial IT acquisitions. And initially that might sound like a home run for a lot of you maybe that are selling commercial IT through an FSS schedule contract like IT 70. But the problem is that while there might be an exception to the BAA for commercial IT, there is not that same exception to the TAA. So, and the GSA's position, and we have a slide on this, so just to give you a little preview, but GSA's position is that TAA applies to all scheduled contracts. So in terms of like a very often asked question when it comes to IT, well, does this mean that I can supply IT from China, which would obviously not be BAA compliant, is also not TAA compliant. And unfortunately, the answer is going to be no through the schedule, I think in almost all cases, because the TAA applies to federal supply schedule contracts. So it is an exception. So, in certain cases where they're small enough standalone purchases of commercial IT, the BAA would not apply, but it's not really going to be a panacea for those of you that are selling IT through FSS, federal supply schedule contracts. Unreasonable cost is another exception. So, we talked about the price preferences, and, if the price of a domestic offer is not the low offer and is also not reasonable based on the price adjustments, that can be used to justify acquiring a foreign end product. Non-availability of domestic end products is another exception, and this can come up in a few ways. There are class determinations of non-availability, so certain supplies have already been determined. Not necessarily that there are no domestic sources, but that based on the available sources, that they would not be able to meet most of the government's needs. So there's a determination by class of a supply that they're not available, and so therefore the BAA doesn't apply. You can find those in the FAR. It's, again, for most people, probably not going to make a huge difference. It's things like bananas and cashew nuts, cobra venom. So all of you on this webinar that are in the business of manufacturing or reselling cobra venom, there's a class waiver for that. My grandmother would be happy to know there's a class waiver or exception for anise, which she was always such a fan of passing around after meals. But it's for many contractors, the class determination is probably not going to make a big difference. It's going to be more the individual determination, which on a contract or product basis, there's a determination that particular product for that contract, there's not an available U.S. source. And I think the part to note about this, that would facilitate this exception is that if the acquisition has been conducted through full and open competition and it was synopsized, through in accordance with the FAR, and they didn't get any offers of domestic end products, then they don't need to have a written determination of non-availability, so that you can sort of use the ends to justify the means. There's also an exception called the public interest exception, where this can be a determination made by the head of the agency. It can also be determined when there's an agreement with a foreign government that provides for this. So for DoD procurements, as an example, they have qualifying country end products that can be treated the same as a domestic end product for purposes of BAA compliance. So there's probably a couple dozen or so countries on this list, including Australia, France, UK, Italy, and most of the countries you would expect to find on the list. All right. So let's make a smooth transition from that overview of the BAA to the TAA, the Trade Agreements Act. And on this slide here, 15, we kind of have the nuts and bolts of what is the Trade Agreements Act, and what is it designed to do. It implements U.S. trade agreements, because we have these agreements with certain countries, designated countries, and again, the FAR lists these countries. The World Trade Organization Government Procurement Agreement countries beyond the U.S. are countries like Canada and the EU and Hong Kong, Japan. FTA countries include countries like Australia and Chile and Panama and Peru. So you can look in the FAR and figure out which category the certain country falls in if you're looking at supplying a product that's made in that country, to determine if it falls under trade agreement, under the Trade Agreements Act. I think the key also is to understand which countries do not. So we've got three of the the biggest ones here: China, India, and Turkey. I think the one that we encounter the most is China, and that's probably true for many of you as well, that most often when there's a question about where we can source a product from, or where it's made, or where a lot of the components are coming from, or it's being substantially transformed, that there's a lot of hand-wringing when it comes to and products. Maybe the client would like to supply a product or get components of a product from China, and it's it is not obviously not domestic end product, and it doesn't fall under the TAA either. As an overview of the TAA, and we're getting a question on when is TAA applicable versus BAA, so perfect timing on your question, thanks. So the TAA establishes a prohibition. It's not a preference. So like we talked about for the BAA, although it's written essentially as a prohibition, it's really implemented as a preference for domestic end products. The government could still buy a foreign end product if certain exceptions apply, like the non-availability that we talked about. But for TAA, when the TAA applies, you cannot provide an end product from a non-designated country. It has to be TAA compliant. So that's a big difference. Prohibition versus preference. BAA is a preference. TAA is a prohibition. And the TAA effectively acts as a waiver of the BAA. I mean, that's really what the purpose of the TAA was. It was to waive the BAA for purchases over certain dollar thresholds. And the thresholds are based on the type of contract and the country of origin. And we're getting some questions about the dollar amount, and we're about to get into that. Thanks. But it applies to federal acquisitions whose estimated value meets or exceeds the listed threshold, as I keep saying. And I'm not intentionally trying to be vague about the dollar thresholds. It's just that there are different dollar thresholds. Like I said, there's a list of them in the FAR. We're not going to run through each dollar threshold here. It varies, like I said, by the type of the contract and the country. For those countries that fall within the WTO GPA, which is going to be, many of the ones you might deal with, like I said, beyond U.S., it's Canada, EU, Hong Kong, Israel, Japan, and others. The dollar threshold is 180,000 for supplies or services, and then it's a little over 6.9 million for construction. And when we're looking at the values here, we're looking at the total value of the contract, including options. And that threshold, these thresholds are updated every 2 years. So they're constantly changing. In fact, they've been decreasing. So the 180,000 current threshold for WTO GPA is lower than the prior threshold, which I want to say was 193,000 or maybe 191,000. So it's a fluid threshold.
So turning to the test for the rule of origin under TAA, there's a different test that applies determining based on whether the contract involves services or products. For services, the country of origin is the country in which the firm providing the services is established, and where it's established means where it's incorporated or where it's headquartered, not where the service is performed or provided. So if the firm is established, incorporated, headquartered in the U.S., then the country of origin would be the U.S. for services. For products, it's either the country where the article or product is wholly grown, produced, or manufactured, so wholly, entirely done there, or if the article consists of materials from multiple countries, then it's the country where the article has been substantially transformed into a new or different article with a name, character, or use distinct from that of the article from which it was transformed. So the test is the substantial transformation test. Again, it's a fact-specific analysis based on totality of circumstances, like under BAA, but this is more stringent than under BAA. So the determinative issue is the extent of operations performed and whether the parts lose their identity and become an integral part of the new item. So processing or assembly of components that already have a predetermined purpose does not constitute substantial transformation. So like attaching a handle to pans or covers, doing the attachment in the U.S. to pans or covers which are manufactured in China would not be enough. And similarly, fastening a foreign tool head together with a domestic wooden handle is also insufficient because the parts retain their original purpose. Also touching on software, which is a obviously common product. So for CDs or hard media containing computer software, they're substantially transformed at the location where the software is burned to or installed on the tangible medium. For intangible software itself, the software is considered to be substantially transformed where the software build is performed, meaning where it's compiled and converted to object code. For in one case, including creating lines of code, making executable files, creating the installation package, and creating final media to be downloaded, but did not include, in that specific case, research or programming of the source code prior to the build, or testing that and validation or burning media to the server for download of the software after the build, but was the build itself. And then when you have integration of software and hardware, it could depend on the functionality of the hardware without the software. So hardware that's delivered without any programming and then has, so it's not functional on its own and then has software firmware downloaded onto the device is substantially transformed where the software is developed and downloaded. But if the hardware is functional with generic software and firmware on it that then later in a different country is removed and then reprogrammed to install proprietary software, which gives specific or special benefits, then that is not a substantial transformation because it was already functional when it came to the U.S.
And just before Jackie moves on, there's a question, are you saying the TAA has a threshold of contract award of 180K? Right, for WTO, GPA countries, that's the threshold, 180,000 contract award, and that's the entire contract, all the options.
Let's see, so moving on to the exceptions to TAA, and so these kind of fall into what we were talking about when BAA applies. So TAA does not apply to small business set-asides, acquisitions of arms, ammunitions, purchases for national security, certain sole source acquisitions, acquisitions of end products for resale, acquisitions from federal prison industries and Ability One, and then certain services, which depends on the trade agreement. So you have to go into the FAR and look at what services are exempt based on the specific trade agreement that applies to the country. But services that apply to all the trade agreements include transportation, utility, research and development, services supporting military services overseas. And then the agency has discretion to grant waivers for non-availability, which is like John was discussing under BAA, if there are no domestic products, or for DoD for national interest. But the waivers are rare. And so with the exceptions, generally you need to, the BAA is likely to apply where GAA does not apply. So if TAA doesn't apply, then you can't just assume that there is no domestic content requirement at all. So we've just got a handy little comparison slide here, which goes over some of the stuff that we've already talked about. But in effect, BAA acts more as a preference because during the evaluation process, price adjustment will be added to the low foreign price if the domestic price is not the lowest price. Under TAA, it's a prohibition if it's from a non-designated country. The applicability for BAA applies to supplies and construction. TAA also applies to service prime contracts. For contract value, as we're talking, BAA is when it's over the micro purchase threshold unless TAA applies. And then TAA has the various thresholds that are listed in the FAR. 180,000 for services or supplies, and then close to 7 million for construction. And then the different COO tests, and then the different exceptions and waivers listed here. So you've just got your handy little comparison.
Yeah, I think that's a good at a glance. And as we're switching to the next slide now, it's perfect timing for several questions that have come in related to applicability for small business contracts. So, and many of you listening might be small businesses working on set-aside prime contracts. So for small business set-asides, the BAA applies, the TAA does not. So let's just get that clear. I think it answers a couple of the questions here. The TAA does not apply to small business set-asides, but the BAA does apply to small business set-asides. Now, the regulations are not explicit about whether or not, when we say small business set-asides, do we mean all types of small business set-asides, or do we only mean truly small business set-asides, but not hub zone or SDVOSB or woman-owned or 8A. So I think there's a little bit of a gap in the rules there on, do we mean just plain old small business or all types of small business set-asides in terms of BAA. But there's no doubt that the TAA does not apply. So the question is, applicability of BAA for small business set-asides. It definitely applies to just plain old small business set-asides. I think the government would take the position it applies to all types of small business set-asides. If you're having to make an argument, which we've had to do once or twice, that maybe it shouldn't apply to a different type of set-aside, I think you might have some wiggle room to do that because of the way the rules are written. But that's sort of the general breakdown, BAA versus TAA on small business set-asides. If you are a small business that is reselling a product made by someone else, and there are several questions around this. So if you didn't make the product yourself, but you're selling it to the federal government, a product made by someone else, then you are a non-manufacturer. And according to SBA, and SBA has what's called the non-manufacturer rule, and that rule requires you to resell a product made by a small business in the U.S. So if you're not going to make it yourself, but you're going to resell it as a small business, then you have to resell a product that is made by another small business in the U.S. However, the SBA can issue a waiver of the non-manufacturer rule. So, we were talking before about waivers of the Buy America Act, and there can be, for non-availability, there can be a class-wide determination of non-availability and an individual determination of non-availability. There's a similar approach for the non-manufacturer rule. You could have a class waiver of the non-manufacturer rule, which means for an entire class of products, the SBA has waived the requirement that you must resell a product made by a small business in the U.S. Or you could have an individual waiver of the non-manufacturer rule, which means that for a particular contract, the SBA has granted a waiver of the non-manufacturer rule. And when the SBA issues a waiver, whether it's on a class basis or an individual basis, what that means is that the small business non-manufacturer is authorized to sell a product that's made by any size business without regard to where it was made. So, in other words, you no longer have to sell the product of a small business made in the U.S. You can sell a product of a large business. Now, SBA did a couple years ago reiterate that if they issue a waiver of the non-manufacturer rule, that doesn't necessarily mean that they're waiving other requirements that might still apply to the procurement, like BAA or TAA. So, you might have a waiver of the non-manufacturer rule, but you still have to consider what other requirements, like BAA, for example, might still apply. So one does not necessarily waive the other, but and you can find a list of, just like with the class determinations of non-availability for BAA, which is in the SBA has a list that you could find online of the existing class waivers of the non-manufacturer rule. All right, next slide popping up here is for federal supply schedule contracts. I sort of previewed this before, but just want to come back to it because we've gotten this question a lot. What applies to federal supply schedule contracts? Because, individual orders on a federal supply schedule contract may be well below the TAA threshold, might also be above the micro purchase threshold. So maybe you would think for a particular order, maybe the BAA should apply. But the GSA's position on this is that they look at the total value of the federal supply schedule contract, the total length of it, not just individual orders. And so they apply the TAA to the federal supply schedule contracts. The exception would be if there's a SIN under a given schedule that is set aside. So if you have a set aside SIN, so that's, again, that would be a small business set aside, and we talked before about the fact that if it's a small business set aside, the TAA does not apply. TAA does not apply to small business set asides. The BAA applies to small business set asides. So most schedule contracts are not considered to be set asides, because I'm not familiar with more than maybe one or two schedules that you have to be a small business to get on them. You can get a small business designation on your schedule contract if you are a small business, but you don't have to be. They're not set, generally speaking, schedule contracts are not set aside. But you could have a SIN on a contract that is set aside, and if that's the case, the BAA would apply to those orders. Otherwise, the TAA applies, generally speaking, to schedule contracts.
So first tip for maintaining compliance with BAA and TAA is to get clarity on what applies. So review your solicitations and contracts and make sure you understand what domestic sourcing requirements apply. Whether it's BAA, TAA, as we mentioned before, the Berry Amendment, there's Buy America provisions, and then there are other agency-specific provisions as well. So make sure you understand what does apply. But don't just assume that BAA or TAA do not apply if the contract clause is omitted, because the courts hold that if a contract or requirement is required by law, then it will be read into the contract. And the Court of Federal Claims has done just that to incorporate BAA into a contract from which the relevant FAR clause was omitted. And so if you're not sure what applies, then make sure to raise questions regarding applicability with the agency or as a supplier with the prime contractor. And consider pre-award protest at GAO if you think that the wrong clauses are included and so that they need to be changed, or neither is included and it needs to be in there, or omitted, whatever the case may be. After you submit your proposal, you won't be able to challenge the terms of the solicitation anymore. Also, pay attention to requests for information from the agency. If they're looking for more information to ensure that you're compliant with country of origin requirements with the BAA or TAA, they may need more information to determine what the country of origin is, and so make sure to provide that information. The agency might determine that you're non-responsible due to non-compliance with BAA or TAA, and if you protest that determination, then you're not going to succeed if you didn't end up giving the agency information that it was requesting along the way. It's also important to note that the agency has no obligation to conduct clarifications to get that missing information. The obligation is on the offeror to provide information that's necessary to show that your products are compliant. So next, get clarity on the country of origin. So if you're not sure what country would be determined to be the origin, whether you have a domestic end product, Customs and Border Protection issues advisory rulings which are non-binding and final determinations which are binding on the country of origin. So there are specific regulations that we've listed here that outline the procedures for getting such a ruling from Customs and Border Protection. If you don't agree with the final determination, then you can seek judicial review at the Court of International Trade. Okay, next we've got making sure that your certification is accurate. So be aware, again, of the relevant FAR provisions and certifications. The key here is to understand that unless you specifically list the products that are non-compliant with BAA or TAA, you're certifying that the products are compliant by default. So you need to make sure that you're listing anything that is non-compliant. Consider including clarifying language on your certificates or in the proposal, explaining how you're defining the components of the end product for BAA purposes, or how you're defining the end product under TAA to make it clear, so that you won't face liability for false certifications of compliance. Also keep in mind the difference between components and subcomponents. Also keep in mind that certifications are ongoing, so if you have a change with your sources, then you need to notify the government in advance before making the change, to allow the government to determine how it wants to proceed. And review the products that you're offering on schedule contracts and make sure that they remain compliant.
All right, so what about prime-sub relationships, flow down for BAA and TAA, whether you're the prime or the sub. So this is a pretty typical situation you're going to find yourselves in when you're dealing with BAA and TAA, and I think the first key takeaway here is that there is no mandatory flow down for BAA and TAA. So if you are the prime and you need to flow it down, then you're going to have to make sure you do that in your subcontract. If you're the sub and you don't think it should be flowed down and it's being flowed down to you, you've at least got a little bit of an opportunity to push back there and say, well, there's no requirement to flow this down, so why are we flowing it down? You really have to look at what's the nature of the subcontract and the prime contract to understand if it makes sense to flow it down or not. Ultimately, the prime contractor is going to be responsible. So, when you are the prime, it is important to follow some best practices, especially when you're a reseller, because when you're a reseller, you're not making the product, you're not involved in the manufacturing process, but if the product has to be BAA compliant or it has to be TAA compliant, then you are entirely dependent on your subcontractor to ensure that the product that you're ultimately supplying is compliant. So the best practices there then would be you've got to obtain a certificate of compliance from your subcontractor and of course flow down the requirement, the applicable requirement to your subcontractor and have them certify to you in writing that they're complying. You want to make sure there's appropriate risk shifting provisions in the subcontract, and what I'm referring to there in part is like an indemnification provision, that you want to be protected if the subcontractor's certification is inaccurate and you as the prime end up facing liability as a result of that the subcontractor's on the hook to indemnify you for whatever losses you might incur. And a question that comes up a lot when prime contractors approach us is, how far do I need to go as the prime contractor to confirm that my subcontractor's certificate is accurate? And there's been some case law that has helped to flesh out the prime contractor's obligations. And what I would say is that you want to be careful about making a determination for your subcontractor. We've had some cases where the subcontractors have essentially said, well, look, prime, this is what we're doing. Tell us if we're compliant or not. And that's not where you want to be as a prime. You don't want to make that call for them because chances are you don't know everything about the manufacturing process. For you to be in a position to accurately make that judgment for them, you'd have to be very well versed in all the aspects of their manufacturing process, and you just don't want to go there. That's putting too much. That's shifting too much of the responsibility to you. The subcontractor just needs to certify that they're compliant, and you don't have to go to their manufacturing facility to confirm it. And that's been borne out in case law that you don't have to go to that end to confirm your subcontractor's compliance. Where you would have an issue as a prime contractor is if you had a reason to doubt your subcontractor's certification. So if you didn't have any reason to doubt it, it's perfectly reasonable as a prime for you to accept that certification as being trustworthy, and you had no reason to question it. But if there's something, that you're aware of that makes that certification seem suspect, that's where it could start to be a little bit dicier as a prime if you don't take further steps to confirm that the subcontractor is in compliance. And always good practices here, applies equally to BAA and TAA issues as it does to a lot of other things when it comes to government contracting. Make sure that you have solid internal policies and procedures, a hierarchy within the company for reporting and, chain of command. It's in the employee handbook and your people are trained. If you're doing manufacturing or you're reselling supplies, these things are important, not only to make sure that you get it right when you're making certifications or when you're accepting certifications from a lower stream contractor, but also if there's ever an inquiry, as Jackie was talking about early in the presentation, maybe a DOJ or IG or a disgruntled former employee files a key tam. Whenever you're under the microscope in a situation like that, a lot of what the government is focusing on is whether you had reasonable measures in place to prevent what happened from happening. Were you a quote unquote responsible contractor? Did you take good faith efforts and there was no intent to violate the requirements? At a basic level, you tried your best. You took prudent steps. All having internal policies and procedures and chain of command and training your people, and this is baked into your employee handbook, all of these things go toward demonstrating that you are a responsible contractor. You understood your obligations and you took prudent steps to be compliant. So, it's really important to do it from that perspective too. All right, well, that brings us to the end. We got a lot of questions during the webinar. As I mentioned, we answered a few of them, but the rest of them that we didn't, we'll get back to you by email. Again, we apologize that we weren't able to complete the whole webinar in one sitting and answer more questions in real time, but appreciate everybody's participation. And please don't hesitate to contact Jackie or me. You can send us an email or give us a call if you want to drill down further on BAA and TAA. Thanks so much.